lawyers willing to help, and we did file an action in 1996. We had our one great victory at the trial court in Alaska. It's the only time, actually, to this day, that a court has ruled that the right to marry can be found in the rights of privacy. And what the court did is draw from Alaska's explicit right to privacy in its own constitution, and then define that right to privacy as the choice of one's life partner. Not so much the choice of an opposite-sex spouse, but the choice of one's life partner. When, by the time it got to that definition, the result and conclusion was easy. The court finds that the choice of a life partner is personal, intimate, and subject to the protections of the right to privacy. Government intrusion in the choice of a life partner encroaches on the intimate, personal decisions of the individual. This, the Constitution cannot do, does not allow unless the state can show a compelling interest. That's as far as this case got. The court ordered the parties to brief and have a trial, really, on the compelling interest. But before that trial could occur, the people of Alaska amended their constitution to ban same-sex marriage, which mooted the case. And then, so early on, we see another troubling sign with these marriage cases, which is a response, a backlash by the people at the polls to rescind court action. That famously is also what happened in Hawaii around the same time. In fact, the vote in Hawaii was on the same day as the vote in Alaska in 1998. So by the time the action moved to Vermont in 1999, these are the plaintiffs in the Vermont case. They just showed me how to use this guy here. Stan Baker. The case is known as Baker v. State. I always like the fact that he could see. This is when I say it's a lawyer-managed case. What they did is find the perfect plaintiffs. Stan Baker traces his lineage back to Remembrance Baker, who was a member of the Green Mountain Boys. And so you can't get a more Vermont. And if I ever had children, I'd love to name them Remembrance. So by the time the same-sex marriage movement reached Vermont in the late 90s, courts were already aware that no matter what they ruled, the people might have their say with a vote at the polls. And so what the Vermont court did, again, this is all just a very brief history of marriage before we come to the cases at hand. What Vermont did, which was surprised everybody really, it ruled that yes, the Vermont Constitution does require the state to afford all the rights, benefits, and responsibility of marriage to same-sex couples. But it stopped short, at least the majority, stopped short of ordering the state to issue marriage licenses. Instead, it brought the legislature into the fold and said, you are an equal participant in the democratic constitutional lawmaking process. You have an opportunity then to figure out how to solve this, to give all the rights, benefits, and responsibilities in a way that comports with the Vermont Constitution. And this is an intriguing line. We could have a lot of debating points on this issue of marriage, but this is an intriguing line. They actually quote, this whole quote is from Cass Sunstein. When a democracy is in moral flux, courts may not have the best or final answers. In fact, we may want to remember this quote when it comes time to guessing at what the U.S. Supreme Court will do with the current marriage cases. Judicial answers may be wrong. They may be counterproductive, even if they're right. That's the line I want you to remember. Courts do best by proceeding in a way that is catalytic rather than preclusive, and that is closely attuned to the fact that courts are participants in the system of democratic deliberation. So catalytic rather than preclusive. Peter Teachout, professor who's on leave this year, teaching me in Boston, loves the Baker case and loves this judgment and loves this judicial philosophy, seeing the court as a participant, not as an arbiter or a dictator of results, but as a catalyst for change. And he looks to the Vermont experience as proof that this line is right, because what happened is that for all the tumult that came after the Vermont legislature passed the civil unions law, it did air out the issue in the public in a way that a court decision never could. We saw hearings, State House packed with people, hearings where gay people came across as reasonable and arguing for their rights, and at least as Peter Teachout tells it, those on the opposite side looked less reasonable. And so opinions were changed by allowing the legislature into the process. So you want to keep that in mind as one alternative instead of just a yes or no from the courts, a sort of middle ground that creates a dialogue rather than a dictation of results. But then, of course, the big breakthrough occurred in Massachusetts in 2003. That's the first time we actually had real marriage equality in the country. And the legislature in Massachusetts tried the same thing. The court issued its decision in Goodrich. The legislature came back with the civil union bill. You're allowed to issue advisory opinions in Massachusetts. So the legislature asked the court, is this enough? will this satisfy the Massachusetts Constitution? And the court said no. It said that, saving just the name, if anything, increases the discrimination. If you give all the rights, benefits, and responsibilities, leaving only the name, it can only be because of discrimination. There was a dissent that thought otherwise, and it concluded that since the obligations, say, on the federal side and in other states are so different, it might be appropriate to give it a different name. The court said otherwise, and so for the first time you have marriage equality in Massachusetts. Following this decision then was a whole spate of litigators were emboldened at that point to sue elsewhere. We had some great victories, and we also had some really bad defeats. One of the defeats was in New York State, where the Court of Appeals ruled against marriage. This is a long quote. I know you're not supposed to put long quotes on PowerPoint. Give this one a try. It's another attempt at explaining this procreation argument. For those of you who haven't thought of same-sex marriage till today, maybe this stuff is kind of coming at you too fast, but for those of you who have worked on issues related to LGBT civil rights, it's this procreation argument that is continually the one that you have to fight up against. And here's the Court of Appeals of New York, their take at it. Heterosexual intercourse has a natural tendency to lead to the birth of children. Right? Disagree with that. Homosexual intercourse does not. Same-sex couples can become parents by adoption or by artificial insemination or other technological marvels. But they do not become parents as the result of accident or impulse. The legislature could find that unstable relationships between people of the opposite sex present a greater danger that children will be born into or grow up in an unstable home than in the case with same-sex couples, and thus promoting stability in opposite-sex relationships will help children more. This is one reason why the legislature could rationally offer the benefits of marriage to opposite-sex couples only. What I find intriguing about this argument is that it flips an age-old stereotype on its head, because for a long time, gay relationships were criticized as being unstable. Why should we give you the right to marry when you're sleeping around and you don't believe in permanency or monogamy even? Gay relationships were thought of as unstable. This form of the procreation argument actually takes an opposite tack and says that gay relationships are so stable that they actually don't need state involvement. That the reason under this theory that we have marriage is to offer some inducement to opposite-sex couples who might have children by accident or impulse. You have to sort of dangle a carrot in front of them and talk them into this relationship because it's the best way to protect children. And so since it's true that opposite-sex couples can have children by accident or impulse, we need this institution shored up to channel that possibility, that reality, really, and give these incentives enough so that we can provide a nurturing home for children. Since by definition, any opposite same-sex couple that wants a child, those of you who might have gone through this process yourself, know that it takes a long time. You have to, let's say if it's adoption, much work to be done before the child even enters the relationship. You've got a stable relationship. The state doesn't need to worry about you. We need to worry about opposite-sex couples. So we see some victories and some defeats. A great victory, of course, where's Natalie?
Yes.
Iowa, right? The Iowa Supreme Court by a vote of 7-0. Victory. Some losses, like in Arizona and Indiana, we had defeats at the court system. One more take, a shorter one at the appropriation argument. This is from the dissent in the Windsor case, so we're getting current here. This is the case that is before the United States Supreme Court, and this is what the dissent would have upheld Doe. And what the dissent says is that marriage works to combat the risk of instability, which is characteristic of inherently procreative opposite-sex relationships, but absent from same-sex relationships. So this is, again, maybe you're starting to be convinced, maybe not, but I'm giving you different takes at what is known as the procreation argument. So we had all the court action following Massachusetts. Then in terms of positive developments, we start seeing state legislatures for the first time enacting marriage equality without any prompting from the courts. And we can probably say that Vermont was the first here as well, because just as the Baker case was the first to extend all the rights, benefits, and responsibilities of marriage to opposite-sex couples, here too in Vermont was the first time that a legislature voted for full marriage equality without any prompting of the court. It did so of its own accord in 2009, And once it did so, it sort of opened a mini little floodgate. Other states like New Hampshire, we're up to 9 states in total now, plus the District of Columbia, that offer full marriage rights. So that's 1/5 already, just in the short span of 10 years, I guess. So we've gotten that many. Perhaps the most significant result, if you're figuring out like how's the court going to rule, is that in most recent times it's moved even past the legislature to include the people themselves. And so I'm sure you're all probably aware that last November, on Election Day, in 4 states, we had people affirm marriage equality at the polls. This would be Maine, Maryland, Washington State, and Minnesota. The Minnesota one was just fighting back a mini Defensive Marriage Act. The other 3 were affirming full marriage equality for same-sex couples. And I can tell you, as somebody who's been at this for a while, this is just mind-boggling to me. I cannot believe, because we had a string of 30-plus defeats in a row, one after the other. You could just count on it. It was clockwork. Liberal state, conservative state, vote was always the same. And it wasn't even close, actually. It was 2/3 to 1/3. It was a wipeout. Now, incredibly, we're getting the people themselves at the polls voting for marriage equality in a rather diverse range of states. Now, I guess those are all fairly over to the blue side, but still, Minnesota. So, great news if we're looking, again, we're going to talk in just a second about what will influence the court. Obviously, the court is looking for trends. It doesn't want to be too far out ahead of the people. And you can look at other examples of where the court literally counts heads, whether it's the execution of the mentally retarded or the execution of minors. On these issues, or for that matter in the same-sex realm, Lawrence v. Texas and the existence of sodomy laws. In all these examples, they look around and they say, well, only 14 states have same-sex only sodomy laws, or only 5 states allow the execution of minors. They will. They'll look to what the states are doing. And so something like that last November could be more important than any brief ever filed before the court. So the point being then, in summary, all of this action I've been describing in the last 40 years has been through state constitutional law. My students already know this, and I hope those of you who don't have me begin to appreciate the vitality of state constitutions for gaining civil rights. And so everything I've said to this point has been under state constitutional law. But alas, you do sort of reach the limits of state constitutional law. Edward Chemerinsky, the noted scholar, has written an article recently called 2 Cheers for State Constitutional Law. And the title itself sort of tells you how he feels about it. 2 cheers for state constitutional law. They're good, and they've gotten us this far, but they're never going to get you all the way. You're eventually going to have to return to the federal constitution if you want full marriage equality across the country. Which brings us to, you know them, David Boies and Ted Olson. They're famous the first time around for arguing the Bush v. Gore case. It's kind of funny to think that some of these children were you all around for that? So they were on opposite sides of Bush v. Gore. Ted Olson was representing Bush, and David Boies was representing Gore. And so they famously argued it out both in Florida as well as before the United States Supreme Court. Well, after Proposition 8 was passed in California, just by means of, so now we're going to talk about the 2 cases before the United States Supreme Court. The first one is going to be heard tomorrow, and this is a challenge to California's Proposition 8. What the long sort of snapshot history of what's been going on in California as long ago as 2000, as a matter of fact. California passed Proposition 22, which at that time was just a statutory ban on same-sex marriage. People eventually brought suit against Proposition 22, and in 2008, in an in-re marriage case, the California Supreme Court struck that down as violative of the California Constitution, not the U.S. Constitution. Well, then people came back with Proposition 8. And in 2008, in all the hoopla of President Obama getting elected, also there was the bad news out of California that by 52%, so the numbers were lower than they historically had been, but still 52% of Californians voted in favor of Proposition 8. It's easy to read and understand. This is Proposition 8. Only marriage between a man and a woman is valid or recognized in California. This, by the way, is a light version of DOMA's. See, when you talk about, cases before the Supreme Court, ideally, if you had to sequence them, this may not have been the best first one out of the box. Because when I call this a light DOMA, the troubling development that occurred like in the 2000s is not just a constitutional amendment like this one, but one that doesn't stop there and says something to the effect of, nor shall California recognize any domestic partnership, civil union, any other arrangement. It's one of those grab bag things to make sure that no recognition whatsoever for any gay relationship. And commentators have said it could go so far as sort of like a contract. In theory, under the extreme domas, courts wouldn't even be able to recognize contracts between two gay people. So this is a relatively light version that focuses just on marriage. As I said, it passed by 52%. The first action was still in the California court system. What the litigants first tried to do is say that this is a revision of the California Constitution, not an amendment. If it were a revision, you're not allowed to do it by initiative. And if they argued it was a revision because it affected so many laws. What number is out there? 1,049 benefits associated with marriage in the legal system. The court didn't buy that. The California Supreme Court said, no, this is just an amendment. It's perfectly allowable. That's the point where Boys and Olson came in with money from Dustin Lance Black, the screenwriter for Milk. And they got together and paid these people to bring this suit. And what's interesting about this suit then is that it occurs outside the LGBT legal arena. In other words, there are these advocacy groups, Lambda Legal, GLAD, and many others, who bring these cases. This one is a renegade. It's from these are two straight people bringing a case, and so we can also talk about the wisdom. I mean, you can't stop lawsuits, I guess, but just how that might play into how things look. Although I've had students say maybe that's precisely what you need. What you really needed is two people who look like they don't have a dog in this fight. Two people the court are very familiar with. Two straight people, frankly. Come before the court and say, look, I mean, that's how far apart we were on Bush v. Gore. We're here to tell you everyone thinks this is the right thing to do. So that's one dynamic in that case. But what they did is finally return to the federal Constitution. And what they say is that Proposition 8 violates the due process and the equal protection clause of the United States Constitution. So the stakes are very, very high in this case because they're going for the whole thing. They would want what's called they want a 50-state solution. They want the court to declare same-sex marriage a fundamental right. Well, and that's precisely what the trial court did. Judge Walker, when this thing was tried, it was interesting because he held a trial. It was just like any other trial. There were 19 witnesses. But the state, or at that time actually, so just to back up, the state of California decided they couldn't defend Proposition 8. So the supporters of Proposition 8, protectmarriage.com, they then came into court as the defenders of Proposition 8. They brought their witnesses in, but this was where David Boies especially shown is he's a great litigator, really. And so he just really got at these witnesses and had them running in circles in terms of what's best for the children of same-sex couples, what does same-sex marriage do to undermine heterosexual marriage. Protect Marriage's own witnesses didn't really have a ready answer for these questions. And the trial court, ruled in favor of the plaintiffs on all counts. It found a due process fundamental right to marry for same-sex couples, and it found, even under a rational basis, that Proposition 8 fails equal protection analysis. So it's kind of strange, but this got gay marriage litigants worried. You'd think we'd be rejoicing at a result like this, but the continued concern is that this is too soon. And so parties joined in, and actually at the amicus level before the Supreme Court, a number of gay organizations are really arguing not so much against the ruling, but that Protect Marriage doesn't have standing to sue. So just a little bit more on that in a minute. We then have the appeal to the Ninth Circuit. And maybe many of you are familiar with what the Ninth Circuit did. It was a very clever strategy on their part. Because again, I guess you could say, and I want somebody to disagree with me on this point actually, that in 2013, it's too early to declare a fundamental right to marriage for you disagree. And by the way, the reason I'm going to hurry up with my comments, the reason I call this a community forum is I want people to start engaging. So let me quickly finish my comments. What the court did is it affirmed, but on different grounds. And the Ninth Circuit held, using Romer v. Evans, that once you extend a right to couples, like marriage, you can't revoke it for no good reason. In other words, once that right was extended and once 18,000 couples married in California, you're not allowed to repeal that right using Romer v. Evans without a legitimate reason. And the court looked through the reasons for Proposition 8, like the procreation argument, having a mother and a father as parents as being optimal, struck them all down. But the reason we consider that a clever result is it would be a California-only solution, because only in California were marriage rights awarded and then taken away. See, it's obvious what the court was trying to do. It's especially obvious since it was using Romer v. Evans, which was a decision written by Justice Kennedy. In this area, as in so many others, he's going to be the swing vote. Although when I give my guesses at the end, I'll say that it might be as many as 6-3, with Roberts moving over as well. But in any event, you're all writing to Justice Kennedy, and you can use what the Ninth Circuit is trying to do is save marriage in California without creating some earthquake in the 40 states that still ban it. So it said that under Romer, California alone was not able to give that right and then repeal it. Okay? Now but see, so that, even that limited ruling is troubling for somebody who's a worrywart about what the Supreme Court's going to do. One line the court says is, Proposition 8 is remarkably similar to Amendment 2. You know, Amendment 2 was at issue in Romer. Well, I showed you, there's Proposition 8. Here's Amendment 2. You can read along and ask yourself, how similar is that to what I just showed you? The point being that they get themselves all worked up and manage to convince themselves, but another way to look at it is they're not similar at all. That Amendment 2 was, and that's, if you've done Romer in your common law class, you know the reason it was struck down was because its sheer breadth belied any rational basis. Just read it and you can see that this would deprive gays of any claim of discrimination whatsoever. And if you've read Justice Kennedy's opinion, you know that he goes into a parade of horribles about how you could be denied insurance or you might even not get fair treatment in court and have no redress for that because you don't have any claim of discrimination. Across the board, he said it's both over-inclusive and under-inclusive. It applied to everything. Proposition 8 appears to apply to just one. So even a one-state solution can be problematic. I've long worried about, well, what? Because see, this is not the first court, the Ninth Circuit, to do this. This mechanical application of existing precedent. You know, like in the Boy Scouts case, they take that, and then for the Solomon Amendment case, we apply it and you lose. This mechanical application where you see a rule and then try to apply it can get you into trouble because, well, at least arguably, a lot more was going on in Romer than in this arguably more limited setting. Now what I'll turn to the next case in just a second, but to make this even more interesting, what the United States has done, they filed an amicus brief as well in the Proposition 8 case, and what they have offered is what's called, they called it at the time an 8-state solution. We can actually expand that now. It's now a 9-state solution because Colorado last week authorized civil unions. Under this so-called 9-state solution, they take the reasoning of the Ninth Circuit and apply it a little further and say that if you've gone so far as to offer civil unions to everybody, to same-sex couples, denying them the right to marry is born of nothing but animus. So they use the Romer case and take it a little further. Instead of saying just California, they offer what's now known as a 9-state solution, saying for those 9 states with civil unions, there's no rational reason, this is the United States government talking, President Obama, there's no rational reason why you don't also extend the word marriage. And so there too, it's an attempt to gain some victory for gay rights without going through the whole thing. So we've got the 50-state solution, we've got the 9-state solution, and of course what the proponents of same-sex marriage are asking for is the 0-state solution. That there's no fundamental right, and that propositions like Proposition 8 do satisfy rational basis. And so that's the merit side of Proposition 8. You're probably aware that there's a standing side as well. And the court itself called this question after it granted cert. The question being, once the state of California dropped out of the litigation and turned this thing over to the proponents of Proposition 8, do those proponents have standing? Have they suffered an injury in fact that's particularized to them? And is it redressable? So the standard categories of standing, but applied in this case to proponents of a measure when the state itself doesn't want to defend the law. And so we can talk about whether it's wise for the court to take a prudential approach here and get out of this whole problem altogether by just limiting their ruling to standing. Okay? So that's the DOMA case, I mean the Prop 8 case. The other case is Windsor. Here is Thea Speyer and Edith Windsor back in their younger days. This is a Second Circuit case. And here they are later in life. Thea developed MS and passed away. They met in 1965 actually and were together for over 40 years. And when she passed away then, Edith Windsor would be responsible for $360,000 in estate taxes because she's not eligible for the spousal deduction due to DOMA, the Federal Defense of Marriage Act. So she sued in the Second Circuit asking for the court to strike DOMA down. So the first case is about the state Proposition 8 amendment. The second case on Wednesday is about the Federal Defense of Marriage Act. So, so in this case, this is seen as much more limited than, oh wait, I'll hold off on that one for just a second. This is a much more limited case than the Proposition 8 case. Maybe I should turn to some, I don't want to call on you. Anyone want to, because my students are working on this case. I don't know if you guys want to chime in at this point. But this is, the plaintiffs, in this case, the plaintiff, Edith Windsor, is not asking for a fundamental right to marry. Her claim is limited to the Equal Protection Clause. It's carved in a way it's focusing just on Section 3 of DOMA, which defines marriage as a man and a woman for all federal benefits. It's projected, it's presented as a more limited, not as drastic. It would only apply to those couples who, same-sex couples who are legally married in the states that allow it. It would say nothing about all the states that ban it. As amicus briefs have pointed out, though, I tend to agree, that might be the sort of effect the day it's issued. But obviously, if the court goes about the business of striking down DOMA and saying it doesn't apply, it doesn't satisfy rational basis, or it doesn't satisfy some heightened level of scrutiny, it's obviously going to undermine the argument for bans on same-sex marriage everywhere. So what I find interesting, my observation is, Proposition 8 gets all the attention for being perhaps rash and too soon. This case, the Windsor case, was brought by the inner clan. It's brought by one of the gay advocacy groups, and it seems like they're getting off with much less controversy in terms of the wisdom of that suit, because it is presented as a much more limited attack on DOMA. But still, when the net result will be that the Supreme Court will strike down the definition of marriage, it seems to me that that's a pretty far-reaching and radical result. The main play here, and this should be familiar to any law student, is over what level of review applies. All courts until now, at least all federal circuit courts, have applied rational basis to claims of discrimination based on sexual orientation. The Second Circuit, for the first time ever, applied heightened scrutiny. It went to the standard the 4 prongs, and looked to a history of discrimination against gay people. It looked to whether that characteristic is in any way related to your ability to contribute to society. It then looked, controversially to the immutability issue, and it said that immutability shouldn't be seen so much as something you're born with, or that you just can't change, or that somehow is in your genes, but more whether it's so central to your identity that it would be abhorrent for the government to ask you to change. That's how it defined immutability. And then finally, politically powerlessness. It said that even though gays have gained some ground in certain areas, like the repeal of Don't Ask, Don't Tell, and some of these marriage acts, it seems evident that they're getting nowhere on the Federal Defense of Marriage Act. And so it said that even today, gays are politically powerless, or at least don't have access to power in the same way other groups did. So having satisfied all 4 prongs, the court applied a heightened level of scrutiny and concluded that DOMA didn't pass it. And so then it went on to appeal to the United States Supreme Court. The court granted cert, and here too, though, the court itself added 2 questions. The only question the parties had up before it was, does this violate equal protection? The court added a standing question and a jurisdictional question. The standing question, you're probably familiar with this, but so just like the California AG said, I'm not defending Proposition 8, you're probably aware that Attorney General Holder in February of 2011 said, we're not defending DOMA. We think, just like the Second Circuit ultimately held, we think that discrimination against gays is subject to heightened scrutiny, and we don't feel that DOMA satisfies that level of scrutiny. So DOMA was without a defender in court. this group of representatives in the House then got together with what I think is the unfortunate acronym BLAG. BLAG. Bipartisan, another thing with acronyms, you can't remember what they stand for. Bipartisan Legal Advisory Group, I guess is what BLAG stands for. It's actually just a group of about 6 legislators who got together, spending your hard-earned tax dollars to defend DOMA in court. It was just fine with the Second Circuit. They said they had standing. And the issue of standing wasn't even appealed, but the court then said, you brief the issue of standing. Does BLAG have standing? Then on the jurisdictional question, since the administration doesn't want to defend it, the court asks, does the Supreme Court lose jurisdiction when the executive branch doesn't want to defend the law? So those very important questions are before the court as well. How about if I stop there and ask for reactions? You probably all want to know what I think is going to happen. What do I think is going to happen? One argument is that we'll have a victory for federalism in both cases. That the court, whether it's the one-state solution or the 8-state solution, will say, in the Proposition 8 case, states are free to say, to ban same-sex marriage, basically, and that we don't get involved. That's a state decision. Marriage, as you know, family law in general, has traditionally been in the province of the states. By the same token, on the DOMA case, Windsor, on Wednesday, once a state decides to offer marriage, well then the federal government shouldn't get in the way and limit the rights that those legally married couples are able to obtain on the federal side. So maybe it's a victory for federalism in both cases. What pundits have said is, will this be, Brown versus Board of Education, Loving v. Virginia, or Roe v. Wade? The court can either make history, it can stall history, or it can send history backwards. And again, what even gay pundits like William Eskridge at Yale they're comparing this to Roe, and saying just like the backlash for Roe has created a generation worth of conflict, and we seem to be losing rights as we go along, that same thing may happen if the court goes too far with this decision. Last thought I have, and then I will turn it over, is that final slide. Did you catch that article last week in the New York Times about gay opponents of same-sex marriage undaunted by the battle? And so as the arguments shift, I wanted you to assess this one. The point being that it's, the received wisdom is that young people, they just don't get it. The times are changing, and things will eventually iron themselves out because young people are going to lead the way. Well, this article wanted to point out that there are actually young people who oppose same-sex marriage. And I don't know, what do you make of this argument? It's not passing the laugh test?
It doesn't pass my laugh test, Professor Johnson.
It makes no sense to me, I'm sorry. What does sexual orientation have to do with whether you're monogamous, exclusive, or permanent? I don't see how does redefining marriage to include same-sex couples relate to those three things.
Is sexual exclusivity a norm that we can really point to?
It's a goal.
Yeah, it's maybe a goal.
The thing I kind of object to in this is, one article I wrote was on this whole thing about playing the loving card. An age-old debate is, again, the value of loving in the same-sex marriage debate. Well, see, loving's a problem for opponents of same-sex marriage because history does show that there were people who did support bans on interracial marriage. And then when that was gone, what they do is they look back and they say, oh, well, that was actually just discrimination. That was layered over on top of marriage. It was never really a part of marriage. That's just white supremacists. And don't look. That doesn't work because now we're talking about the definition of marriage. We're not talking about something that was layered over that definition. But really, in my opinion, at least, when you look at the research, it was considered as much a fundamental part of the definition of marriage as today's opposite sex, part of the marriage definition is today. It was universally, in fact, at the time of Loving v. Virginia, polls showed that the American people opposed interracial marriage by much greater margins. Well, in fact, today, the majority of Americans support same-sex marriage, but much greater margins. 70% at the time of Loving v. Virginia in 1967, 70% of Americans opposed interracial marriage. So I guess, arguably, the court was ahead of its time even then, too. So what do you think? What do you think about all this? Another angle would be that the court would take the prudential route and get rid of these cases on standing and wait for another day. I don't know. It's funny for a law professor to say this, but even if that's true under the rules of standing, even if you can't show how black suffered an injury in fact that's distinct to them, even if all that's true, won't it be strange when the whole country's waiting for a decision and they say, well, we're sorry, we can't hear this. We're the Supreme Court, but we can't hear this. Again, that's a very unlegal thing to say.
But then my question is, why would they grant cert if they were planning?
Yeah, if they were
Yeah,
going to do it.
especially since the court itself added those questions, it clearly seems to be that it's something they're interested in. At least on the presidential one, it struck me in passing that maybe they created that question just to take a swipe at the president and say, like, what are you doing, not representing the United States government, and isn't your task to take care that the laws are faithfully executed? Why are you not in court? I don't know. That's just a random thought. Remember, you need 4 votes to grant cert and 5 votes to win. So another thought is that 4 of them really care about standing, but does the 5th? Any thought? I know that Professor Perreno is actually an expert on standing, whereas I am not.
I think Windsor's gone. After Clapper, I don't see it in any way, shape, or form. The court just handed that down a month ago, saying that the injury has to not only be, particularized and concrete, it has to be certainly impending. I don't see Windsor surviving.
And the difference, the court actually asked this professor to write an amicus brief on the standing issue, which I think is pretty rare, right? In Supreme Court, right? And what this, you want to explain the Chava case too?
Oh, the immigration case?
Yeah.
You tell me what you have in mind.
Okay.
I know the case, but I'm not sure
what this amicus brief says. In that case, Congress passed a law that says if the INS grants asylum to anybody, we have the right to say no. We can veto that decision. Well, the INS did grant, whether it's asylum or refugee status, I may be getting the term not quite right, but granted refugee status to, and then Congress came in and said, no, we veto that.
Yeah.
And what happened there, though, in that case, is both houses of Congress came in, and the president said, well, I'm not going to defend you. But both houses of Congress came in, and all Congress was really considered the party in interest. Whereas here, you really do just have a collection of 6 or so.
Yeah, I just don't see that survive. I think the Proposition 8 case, I think, does survive. And I think Duke Power is the precedent. That's the case that decided whether or not the liability cap on nuclear accidents was constitutional as a due process question. Clearly, there's never been, thank God, other than 3 Mile Island and near miss, there's never been a nuclear accident. There's no reason to believe that if there ever was a nuclear accident that anybody would be damaged beyond the liability cap, right? And that was real clear from the briefing and argument before the Supreme Court. The Supreme Court had a golden opportunity to say, we don't need to decide this question today, we're not going to decide this question today. They decided it because they thought it was important to decide it. And I think on that one, I'm thinking they're going to reach it.
On Prop 8.
Yep.
Well, let me turn then to the Owen case and address my ill-defined unease. So the net effect of that then will be, at least as long as President Obama is president, these decisions are immune from review, that the Second Circuit decision?
Yeah, I mean, I think from Kennedy's standpoint, I think he wants the respondents in both these cases to win. And I think he's going to find the narrowest ground to let them win. Pragmatic. That's who he is.
Yes, he is. And what do you think I mentioned earlier, the 6-3? Any chance that Roberts would join?
I think there is. Particularly with Ted Olson standing there.
Yeah. Good. Amanda?
One of the things that sort of is interesting to me is even if Windsor gets tossed on a standing issue and they decide there's no standing, publicly, doesn't that still undermine DOMA? Like just in public observations, because it's basically saying the president's not going to uphold this, so we're not even going to hear this case if the president's like, we're not arguing this anymore.
Well, I suppose any ground to be gained on that front would have occurred already once the decision was made not to defend it. I think if it ends up on standing, I don't know, it would be so lost in the arcane world of standing that most of Americans won't go past the headline. So is this a good time then to argue for a fundamental right to marry? Are we there, Kristen?
I think so, but my question kind of goes back to when you guys were talking about standing. I guess I'm confused because I thought Prop A case would have been the one that wouldn't survive standing because it's being brought by a group that's not actually directly being affected. I don't remember the definition.
And on top of-
and with
Yeah,
certain
I
is
agree
a-
with
is
you.
a
I think
person.
if standing was a principled doctrine. No, I'm serious.
Okay.
Peter Teachout in an email this morning added one more concern, which has been raised by Walter Dellinger in his own amicus brief, is the lack of political accountability. If you hand it over to just the proponents of Proposition 8, where's the political accountability? And there's threats in the briefing that if you allow this, then you're going to suddenly constitutionalize, and make litigators out of every proponent of every amendment to every constitution. Is sort of a slippery slope argument. I want to turn actually to Katie because she said something wonderful in that great class, Sexual Orientation and Law, last week. Because again, I don't have, I tend to be a worrywart and always expect the worst to happen. But you put it really in perspective, and no matter, these are momentous cases to be sure, but they're just actually one more important episode in the battle, that it won't end here no matter what the court holds. And what you brought in that study, sociological?
Yeah, one of my favorite books from college was written by a professor whose name was Michael McCann, which I was very confused about when I got here because it's not our Michael McCann, but he's a professor at the University of Washington. And he did a study on the women's pay equity movement. He followed the organizers, the grassroots organizers on the ground, and then the court cases that were filed on the local and state levels, and found that when they won in court, obviously they won a court victory, but when they lost in court, they saw their grassroots on the ground, that kind of organizing, shoot through the roof. So no matter what happened in court, because they were able to translate losses in court into boots on the ground, they were actually still making progress. So it was one of my favorite books to read, and made me confident that coming to law school could be a good thing. So, but I think that we'll see with the Prop 8 case that the way that this question has been worded, I don't think either of these is going to be groundbreaking. I don't think either of these will be no cases 20 years from now. We have yet to see the case that has the perfect plaintiff and the right question and the right panel. And so I'm not such a worrywart. And I've told Professor Johnson to take a deep breath.
It's kind of reassuring to think that this is just part of the story, not the end of the story. And when Katie made that comment in class, I honestly did flash back. Bowers v. Hardwick really did help mature the movement. And when that decision came down, when you suddenly realized, wait a minute, I don't have any rights at all, that you said, well, let's get started on this. Let's see if we can change that.
And to look at that from the early rights perspective, we're seeing the backlash, yes, but we're also seeing people stepping up to fight that backlash and be like, wait a second, we have these rights. You can't, so I think even if you talk about it setting us back, that's recoverable. So while I worry, I'm not entirely free of worry, I think that we will recover.
Yeah. And the thing is, it really is a state issue. So if the Supreme Court says, no, it's a state issue, we kind of already knew that already. So let's let these changes happen at the state. This might just be a little blip along the way. I mean, every week there's news to tell, isn't there? I mean, last week it was Colorado. Crystal, you know Illinois. Marriage equality passed in one house and is moving on to the other. What's next? Rhode Island, Delaware. I mean, it really is breaking out all over. I guess suppose, again, in the context of two cheers, you will finally run up against the outer limit. And the Alabama legislature is probably not going to be voting for marriage equality, or, well, Mississippi maybe. No. So I guess you do run up to the upper limit, but we haven't reached that upper limit yet. And it seems like states are joining left and right.
We were also talking about trends earlier, and recently there was a kid, I don't know how old he was, he was younger, and now he was gay, he was also autistic, and I think he was brutally murdered. And so that's it's a headline that's going on right now, and Bradley Manning, his case is not really related, but he was also gay and in the military. And so there's I mean, in the news, there's always something going on in the community that, I think draws their attention to it. So even if they don't make a real decision on gay marriage being, all 50 states or, whenever they decide, I think they're gonna have to make some kind of comment that like in the future, people are gonna pick up on, and that's gonna be the one-liner from this case.
Good. That's an excellent point, actually. In fact, Katie started by saying go to SCOTUS blog. Obviously, you probably all do it already, and that point has been made there as well, is that whatever comes out of this, the tea leaf readers will get inklings. I did want to show you one brief on SCOTUS. Our friends, the Westboro Baptist Church. They filed a brief, and well, it only has one point in it, actually. They didn't take legal writing from me. This brief includes a 4-page block quote. Where does it start?
From the Bible?
Yeah. Starting right there.
Whoa.
I mean, it's
Utterly destroyed. Your supplings are going to be destroyed. So, okay, but the point though being, more seriously, again, we can get all very comfortable in our opinions. Well, what's the big deal and stuff? You should appreciate that there's forces aligned against marriage equality. And in fact, if you're just counting briefs, there are way more amicus briefs in favor of Proposition 8 and in favor of DOMA than against. So we should make sure that here at Vermont Law School, we all know what's right and what's wrong. Now, we realize that there are people out there who disagree, and you have to confront them on their arguments, not so much just in some dismissive way. Yes?
I'm just talking towards progression towards the movement, regardless of how much ground may or may not be won in these cases. I think that's something that's very interesting, is that the conservative CPAC, for a very, very long time, have not let people from the conservative movement come and talk about pro-gay rights. And recently they've changed that. They've let them come in, and a lot of the conservative movement is talking that people are saying not only do we need to look at the Latino vote, we need to look at the LGBT vote. And so that's something that's, even from the other side, something that's groundbreaking movement in the last New York election. So.
Good, yeah. And that is what it's going to take. What do you think about this point, though, that the New York Times was trying to make last week, that even among youth, that if you read the whole article, you'll see later they say that this is a generational battle that we're prepared to fight and not stop. And is it a mistake to just think that all youth are going in one direction, or is there a backlash even among youth?
Well, I think what you were saying with possible backlash is this case too early for those of us who are on the pro-gay rights side of the aisle. I think actually in upper echelons of sort of establishment Republican thought right now, there's the same concern, because if this gets voted down, if it appears to be a defeat for gay rights, they are sitting there holding the ticket that has put us in this, in a position where you have the majority of the country think it's a good thing, and we can still, as Democrats, say work on this issue. And I think that it is nothing but a losing issue for them in long-term future.
Long-term future, yeah.
Yeah, and I think they're just worried about backlash.
Yeah, you used to think, well, maybe 50 years from now we might start seeing change. It's again happening by the.
I mean, they don't want this in 2016. I mean, they really want to get rid of this issue. That's why there are, a lot of establishment Republicans are trying to shed this as fast as they can.
Is Portman, is that his name, the senator in Ohio? Yeah.
I think the New York Times article and the procreation argument is just obtuse and ethnocentric. I guess, it's imposing this sort of, I think of like 1950s ideal of the way to have a child is with a man and a woman in a little house, without, you can't have grandparents, or any cousins living with you, because that would just destroy you know, the whole thing. And it's just, it's based on false assumptions, you know, and it doesn't take into account that, you know, healthy children come from other types of environments too. I mean, I come from an indigenous community where it is very much, you know, a sense of community, and children are raised by other relatives, you know, watched a lot by cousins, my grandparents, aunts, uncles, and there isn't this, I don't know, like, I don't think that children without, you know, married parents who don't know their extended family and everything have any sort of benefit other than, you know, what some church might bestow their blessings upon them, I guess. But it's just, it doesn't appreciate that there's a bigger world out there, and that there's other ways to have healthy, happy children.
I'm going to turn to Carmine. You certainly agree with that, don't you? Carmine wrote this excellent paper this semester. Boy in the Bubble, it was called. Talk a little bit about that.
Well, it was actually about the Hernandez case. I'm from New York, and when I read that, I didn't know about that case, so I kind of feel that whole, I don't know. Anyways, when I read it, I was like, this is New York. Like, I live in a New York City bubble where everything's very liberal and, you know, Greenwich Village type stuff. So you think, like, New York, like, there shouldn't even be a question. And then that was filled with things about, like, you know, procreation and, you know, kids need to be raised within the household of a man and a woman. And I was just like, okay, that's not even, it's dismissing also people who are not homosexual, who don't, like you said, aren't raised that way. I was raised with my single mom, dismissed her right out the door. Like, yeah, that wasn't a healthy household, apparently.
Yeah.
Apparently, right? So it's just really interesting of how it kind of just looked at, and I called it bubble one because it really just looked at like, this is the only context where kids are exposed also to other people, and that's really not true. As we know, we go to school, we go to parks, you live lives outside of the family home as well. So it's just really interesting.
Well, the procreation argument also seems to fail for two other reasons. I think there are people who can't or don't want children who are heterosexual. Nice to meet you. There are also, I'm the one. There are also I feel like there's the argument that the conceiving children can actually create instability within households. Believe it or not, some people are getting married because they knocked their girlfriend up, and 10 years later they realize they're in an abusive or unhealthy relationship, and there's no way out because they have a child and they're stuck. Whereas I think people who are planning their families a little more carefully, whether they're gay or straight, tend to have much more stable relationships and families.
Okay, good. It has always seemed to me that what's happening is they identified the one thing that gay people can't do, and then they just build a whole argument around it. I mean, does that distinction really have meaning? And is that actually the reason for marriage? We saw that quote earlier, where it's actually meant, they go so far as to say for the survival of the human race. And what Boyce and Olson do in their brief is say, not once do the proponents of Proposition 8 use the word love in their brief. Not once. So, Justin?
As far as the youth concerns go, I think if you went and revisited a lot of the people they talked to in that article in 5 or 6 years, after they've gotten out of their sheltered environments and maybe gone to college, made friends, experimented a bit, done whatever. I mean, things change over time, right? And I think that especially, if you're talking about the arc of justice, especially when it comes to the marriage debate, society tends to shift, and I think we'll see those people shifting along with it.
Mm-hmm. And then eventually maybe the Supreme Court will come back, and just like they did with Lawrence. If we get an answer decision this week, they'll come back in 15, 20 years once.
I mean, yeah, definitely that. I don't see the long-term outcome for marriage being one that's discriminatory.
Well, then I guess you support polygamy as well, don't you?
I mean, consenting adults and whatnot.
What are we left with in
I
society?
don't want to be limited to only having one husband or one wife. That's just not hard to contract.
Amy.
I think that when you say like what are the purposes of marriage, and I feel like the fundamental foundations of marriage are religious, and that when the state supports them, that's problematic in general. And sometimes I think when groups, you know, they're seeking to expand the blocks or whatever, just like want to try to cram themselves into it, and you uphold marriage as this, you know, ideal, that doesn't allow for a lot of paradigm shift in the culture in general, and that there may be problems with trying to just cram everyone into this very narrow definition.
Thanks for getting us back to that point. That's a very, very valid point. Like the old saying goes, you know, marriage is a wonderful institution if you like living in institutions. One more, and then we probably should break.
Well, I was just wondering, you were saying that there were more briefs in favor of Proposition 8. What the funding disparity was, or
Yeah.
if you had a sense of disparity in resources between the two sides.
Well, that's a very loaded political question itself, actually.
No, because, well, just
Yeah.
the point that if the polling is dramatically shifting on this, how long, even if there's a funding imbalance against gay rights now, how long will that be sustainable for those organizations?
Right. Well, with time, I guess time will tell, won't it? A lot
But
of
is there a major disparity in resources right now?
Well, in Proposition 8, the fund, there was a disparity in terms of,
At the state level.
yeah, at the state level.
Yeah, no, and I got that
Right now.
impression, but currently is.
I mean, you're asking me, it's hard to say, like, you know, who's got more money.
Scalia said.
Yes, Scalia. Justice Scalia says that gays have more disposable income. Yeah.
Gay men listen, but not women.
My own sense is that funding is fairly even. One last line in terms of the briefing though. This one pundit talked about the dog that didn't bark. As I said, there are 42 briefs in support of Proposition 8, but of the 41 states that prohibit same-sex marriage, only 20 signed on to the brief in support of Proposition 8. So that's the dog that didn't bark. 41 states ban same-sex marriage, but only 20. When you talk about like getting out of this issue, only 20 of those states actually signed a brief saying you should uphold Proposition 8. Okay, onward to the future. Don't fear the future.
I want to take a minute to embarrass you.
I was drunk, don't
What happened in Moscow stays in Moscow. No, this is for the aspiring advocates in the room. This is an issue deeply felt. This is more than an academic interest to Professor Johnson. And yet, if you've been paying attention, you'll notice several salient points. He's respectful of arguments that he doesn't agree with and the people who make them. He's analytical, he sticks to the law, he sticks to the facts, he doesn't overstate the case, he makes the case. And he makes it so compelling. It's no surprise to me that marriage equality and a larger concept of equality is emerging, and it's because of advocates like Greg Johnson.
Well, now you are. Last word, it's too late to go see the argument. Did you catch the story where people started lining up on Thursday?
Yeah.
So check it out though, you know, on that's OI8, like you said, Katie.
Yeah,
on OI8.
they've already said they're going to release the transcripts the next day.
And the audio.
Excellent.
So for everybody who asks you when you tell them that you went to this awesome thing today, let them know that there will be a link. Thank you to Bill Bond for being here to record. There'll be a link to that, and then we'll also link to the oral arguments, and all of that should happen hopefully by the end of the week-ish. So thank you all so much for coming today. We really appreciate you coming out.
And if your chair came from across the hall.
Oh yeah.
Oh yeah.
If your chair is a blue chair, it goes to Yates. If it's a black chair, it goes across the hall to 9 Thomas.